Welcome to Mastering Legal English, episode 4, where we focus on making legal English content for lawyers. My name is Charlie Shannon. I'm a Canadian lawyer with a UK law degree who's become an English coach for European lawyers based in Spain. And I'm joined by...
I'm Steve Kahaner, a U.S. lawyer who practiced internationally for several years, mainly relating to Latin America and Spain, and who now owns and runs a language services company focused on the translation of sophisticated legal and corporate documentation. And today we have a special guest. Peter, please introduce yourself.
Hi, I'm Peter Nemias. I have an alternative dispute resolution business here in Madrid. I'm a lawyer, I'm a mediator, arbitrator. I'm also a law professor at two universities here locally. Admitted to the bar here in Madrid, as well as New York and New Jersey.
Great. Thanks, Peter. Now, back to business. If this is your first time listening, you may be wondering why we're doing this. Well, for me, learning French and Spanish changed my life by helping me find work in Canada and Spain that I wouldn't have been able to do otherwise. And because English is an even bigger international language than Spanish and French, I clearly see the power it gives to people who master it as a foreign language. It's not something that people in Canada or the States realize because we take the reach and ability of speaking English for granted. Also, I've been coaching lawyers to speak and work confidently in English for almost 4 years now. And it occurred to me that a live stream could be a great way to talk about the ideas that have worked for my clients in the past and to mention the methods I'm using now too. I also just like learning and teaching languages. In fact, I enjoyed learning French and Spanish so much that I've started working on learning German too. Steve, can you talk about your motivations?
Sure. We've been helping our clients with their English language materials for decades now. And I thought it'd be a good idea to participate in a podcast where we discuss what I refer to as comparative legal linguistics and the issues that non-natives of typically have when trying to express themselves in the English language, especially in the legal context. But also, in my prior life, practicing international corporate, commercial, and securities law, I saw how important it was for lawyers practicing internationally to have a strong command of the English language, and especially English language terms and concepts. And this is because, like it or not, English is basically the lingua franca of international law and business, no matter what jurisdiction you're licensed to practice in. Peter, would you like to talk about your motivations for being here?
Let's see. I grew up in a bilingual environment, and I practice about internationally between the United States and Spain. I've been at this for 30 years. My career has taken a whole bunch of different turns and whatnot. But being able to practice, being a practicing Spanish and American attorney, of course, makes me interested in language as a tool to communicate. I think I probably share the motivation you just explained, Steve. The ability to be able to communicate clearly is really essential when you have a practice of the nature of my own. So.
Well, Peter, cut to the chase. Why does your English sound so native?
Well, you see, I'm from New Jersey, so and my father was from Madrid. My mother's American, and so I grew up getting yelled at and corrected in both Spanish and English. And now I'm married to a Spanish wife who also yells at me in Spanish and will usually correct my syntax or any kind of grammatical mistake, usually the subjunctive, just as I'm about to win the fight that we're having at that moment. So. It's an ongoing thing.
We have that in common, actually. I'm also married to a woman from Madrid, but like a good lawyer, I often try and correct her Spanish, even though I have no right to do so and really shouldn't be doing so because I'm usually wrong, even though I think I'm right. A typical lawyerly habit. Yeah, it's interesting. It's
Fair
kind of like
enough.
the old. There's a refrain that most lawyers don't write well, but think they do, and
Right.
so it's along those lines.
Great. Thank you, gentlemen. Well, since we have Peter on as a guest today, we're going to focus more on the language surrounding alternative dispute resolution, or ADR. So we're going to start with an Ask Us section with our opinions and advice. So please put any questions or comments in the live chat. And then we'll speak about legal English terminology in the ADR sector, after which we will discuss our controversial opinions for the episode. And finally, we'll finish with a quick word from our sponsors. But now it's time for Ask Charlie. Steve, do you have any questions for me today?
Sure. First of all, why are we doing this on a Wednesday and not our usual Friday at 6 p.m. Central European time?
Well, I guess I can answer that. It's because I recommended it. Yeah.
Yeah, please do explain, Peter.
Well, you see, it's All Saints Day in Spain on Friday, so Charlie and I will, just as a matter of conscience, we refuse to work on that day, as we'll be either probably church and then afterwards visiting cemeteries.
Interesting. Well, that's not typically a day we get off in the States. Why not tomorrow on Thursday?
Right, I thought Thursday was a bad idea because last year I was working at a Spanish private school and all of the kids were talking about going trick or treating on Halloween. And I'd like as many parents to be able to watch this live as possible.
But I thought, what is Halloween that popular in Spain? I thought it was an American holiday.
Well, yeah, I'm not going to say it's just getting started. I mean, it's been going on here for at least 10 years now, but I think it's relatively new. You'll see kids trick or treating in the smaller neighborhoods around Madrid.
And not just the expat communities.
I mean, it probably started there, right? And kids probably saw other kids dressing up and thought, "Wow, that's really cool. Why not?" Right? So, but not exclusively. I mean, my wife and I raised our children in Madrid, and kids just love to dress up for any reason whatsoever, right? So yeah, our kids were doing it here, years ago, and still would if they weren't all in college. So.
Great, so that's why we have gathered here today on a Wednesday. But without further ado, let's go to our first ever Ask Peter segment and get to some ADR vocabulary. Steve, do you have a question for Peter?
Well, yeah, given our focus on translation or my company's focus on translation, I'd be interested in your views on ADR or alternative dispute resolution terminology. Things non-native speakers confuse or might get wrong in mediation and arbitration. So I was wondering what you think is important to keep in mind for the non-native speakers of English.
Well, it's a great question. Probably the one reason you asked me to join you guys today. Yeah.
I mean, I think there's the more basic terms, things like demandante and demandado, in U.S. English, in the litigation context, that would typically be plaintiff and defendant, but in the ADR context, as I understand it, those terms would be translated as claimant and respondent. Is that true? What's the difference with arbitration? What are the proper terms here?
Yeah, that's exactly right. Yeah, I would say that's right.
So,
Yeah, I mean, look, I mean, just to start off on the right foot here. I mean, and I just want to say this to viewers. I mean, most of my comments are really directed really at people starting in this field. In Spain, you have a very sophisticated ADR community. So most, if not all, of the senior ADR practitioners here are for the most part very good English speakers and writers. Many of them have studied or worked abroad at some point. Or for that matter, maybe secretly are studying with Charlie. But but it's because English really is the preferred language of international commercial arbitration. The lingua franca of it, really. I mean, there is, it's important to note, though, I mean, that there is an important push towards using Spanish these days. Yeah.
That's interesting. Why is that?
Well, there's a couple of reasons for it. I mean, I think there's more and more cases coming out of Latin America. I mean, there's some jurisdictions, I believe Peru, if I'm not mistaken, but they have a law in place that mandates arbitration for every case that involves any enterprise that's participated by the state. Right. So it gives a rise to can I just imagine the amount of workload. I think another thing that's happening is, I think, really interesting, is that the Madrid, up till maybe, I don't know, 2-3 years ago, has several arbitration bodies, STIMA and Colegio de Abogados and the Cámara de Comercio, and they, and those organizations had their own, domestic cases as well as international cases. And what they did about 2 years ago is they've created a new international arbitration tribunal in Madrid, where they basically consolidated all of the international work of all the different tribunals and consolidated into one, really with a view to really putting Madrid on the map, internationally, to compete with Paris, the ICC tribunal in Paris, or the London Court of Arbitration, and to draw more of this type of work here in Spain. And I think one of their main selling points is the ability to do cases in English, just like everybody does, but I guess their unique selling proposition is to be able to do the cases in Spanish, right? And so I think that's kind of helping this kind of move towards using more Spanish in the proceedings.
And when it comes to ADR, are there any issues around terminology that you see?
Well, yeah, I'm happy to go through some of the important things to keep in mind. I mean, I once heard somebody, a Spanish speaker, refer to our arbitration as instead of saying arbitration, they'll say arbitrage, because in Spanish it's arbitraje, and the faux ami would be arbitrage as opposed to arbitration, which very, very different. So they aren't, it's not really a fatal mistake, but when you're new in this, when you're coming into a field like this, I mean, it's important to get some of the terms right, and you're trying to build credibility, and so getting the terms right helps. I mean, I have not been practicing in this area for 30 years. I'm relatively new to this myself, so I'm very careful with the terminology myself, So, but I mean, an escrito, what a Spanish lawyer would call an escrito would we call a brief. A demanda would be, a statement of claim. It's not a complaint, it's a statement of claim. It's, there's certain terms of art that you would use in this field, right? Obligaciones, we wouldn't translate it as obligations, but liabilities, right? Spanish, they'll use, they'll translate the term, indemnización to be, I imagine Steve probably seen 50 different ways people say it, but that's compensation.
Yeah, typically, I'll see indemnity, indemnification, and that's not really appropriate in this context. I assume it would be
right.
compensation would be the best translation
Right.
of the term.
I mean, it's very different, right? Compensation and indemnity, it's a very, very different legal ideas,
And even, demanda, complaint would be correct in a court litigation context, but not in the arbitration context. So it's important to know the context of where these terms are being used.
Right. I mean, a duplica, would be a rejoinder. But going to your point there, I mean, you're right. I mean, the decision of a panel or a sole arbitrator, it's not a decision, it's not a sentence, it's not a, it's an arbitral award, right? It's a laudo. Medidas cautelares, you would call interim measures. But which then that can entail injunctive relief, or the Brits might call it precautionary measures. So that's another kind of minefield to navigate too. Is sometimes there's a difference between American English and British English, right? Like I think George Bernard, I don't know, I think it was George Bernard Shaw said something, where common people separated, or what is it, where uncommon people separated by a common language, something like that. So security for cost, for example, that concept. I mean, that's such a special concept in arbitration that it's, nobody translates that, so you just say security for cost, right? Whatever, right? I think ultimately, have things like this. I was just thinking, just preparing for today. I mean, I think one of the, and I don't mean to laugh about it, but I mean, I think it's a really common pitfall with people is dealing with acronyms, right? And again, you guys see this all the time, but if you just kind of come into it, you always say, oh well, if we say it one way in English, well, you just say it backwards in Spanish, right? So NATO is OTAN, right? And you just do that, and in my space, sometimes that works, sometimes it doesn't, right? So like the UN Convention on the International Sale of Goods, the CISG, which so many cases are always about the CISG in international transactions. Well, nobody fiddles with that one. That's CISG. Even the Spanish, CISG. Play with that. But UNCITRAL, again, one of the big bodies of rules for particularly in ad hoc proceedings. I think that the Spanish they fiddle with that. So they call it the CNMUDI, something CNMUDI, something absolutely unpronounceable, right? So you have to advice I would give to anybody coming in is take care it's with things like that. Don't just assume just say it backwards. And don't assume too that that everything's like CISG. That it's always that it's unmovable. I mean, oftentimes when you're moving from Spanish to English, you have to be careful. With the acronyms, right? So. I find I think another thing that comes to mind too is when you're making like references, to American cultural references without knowing what the hell you're talking about. So, example would be something like baseball arbitration. Nobody in Spain, they don't, they think, maybe it's like kind of like rounders or something. Like they don't really know they've never seen Pride of the Yankees. They don't really know what that is, and so they're talking about baseball arbitration, and they don't understand what the hell that's referring to, so,
Right. Well, I was wondering, could we potentially call baseball arbitration final offer arbitration because both parties submit an offer, right?
Yeah, Charlie, spot on. I mean, I think it's a good way to think of it. With you have two proposed settlements. It's one way to choose an award. It has more involvement from the parties. It's a creative way to break impasse, to get to dispute resolution. You can save weeks of hearing time. It's really one of the things that attracts me to arbitration mediation is really the flexibility that the parties have to fashion a procedure that to really expedite things.
And you can even go. I mean, there's even something called night baseball arbitration, where the arbitrator isn't even informed of the proposals. The arbitrator renders their award, and then it's adjusted to conform to the closest of the parties' proposals. So the flexibility is limitless almost.
Yeah, it's
Even
really
more even more scandalous than that, I've heard of putting experts in hot tubs in arbitration, and I'm wondering, is that something you like to do, Peter?
Yes, I do. No, no, before anyone runs away with their imagination, it's a term, hot tubbing, right? Is actually a concept that's sometimes used in arbitration, where you'll put the experts together. So if you have opposing experts that are, imagine, in ordinary litigation, opposing experts. I mean, God, you could be there for days. And so, hot tub them, put them together and see where there's common ground, and maybe prepare one report. It's one of the great, really, I think, really cool things about the handling disputes this way.
Well, definitely the term hot tubbing is something that can get you into a lot of trouble if you use it incorrectly or with the wrong tone of voice or if the other person hasn't heard of it, right?
Well, and even worse, I don't know how often hot tubbing would be in the written documents, but if it was, and you put it through a machine translation tool, I'd be a little worried about how the tool would translate. The automatic translation would come out for hot tubbing of the experts. I don't know what you think, Peter, but
It's hard to disagree with you, Steve.
clients have to make a decision about translating some of these documents, and I'll you know nobody wants to spend additional money, and it's hard to compete with free. It's hard to justify paying for professional translators, much less specialized lawyer linguists, when you have documents that need to be submitted to an arbitrator or a court. But you need to kind of think about the risks involved and what the risks are of getting it wrong, and what risks you're comfortable with, what risks you're aware of, the types of risks. There's the client privacy issues and confidentiality. If you're using a free tool and you're just uploading a confidential document, what kind of breach of ethical codes might be involved, much less the actual issues of errors in the translation by the machine, the large language model like ChatGPT, or the machine translation tools like DeepL or Google Translate. Are the lawyers thinking about these things? I don't know the extent to which
Mm.
they're really concerning themselves.
Absolutely. And also, Peter, I'm wondering, do you find many conceptual challenges coming from the fact that we've got civil law trained lawyers? I'm just thinking about, for example, orden publico. Would you say that's just public policy or something else?
This is an interesting thing to talk about because, you know, um, I think we'll talk about it later on about functional equivalence and whatnot. But yeah, let's face it. No, orden publico, is not just public policy. I mean, it's a much more extensive concept particularly under civil law. I mean, it actually would include the criminal code. Right, like in other words, to do something, this contract or this agreement, whatever, might be in contravention of sanctions or a criminal violation or something like that. And so, so it's a it's a much more extensive concept than simply just saying public policy, right? So it's that now all that said, right? I mean, again, most of the seasoned lawyers in this field are very familiar with these types of distinctions, and you know but that said, I mean, people do come to these things from different cultures. So a classic example would be something like force majeure. In my view, European lawyers are more familiar with the concept than common law lawyers because and I know we can debate this, but I mean, because it's a creature of the code itself. I mean, so you don't need to actually stipulate it in your contract because it's already there by application of the civil code itself. You can tweak it and you can do stuff, but it's already there. And in common law, it's a creature, it's a conventional thing, right? And so yeah, I mean, in common law, like yeah, we have very carefully drafted force majeure clauses, and they're they're wonderful, but it's a creation of lawyers put in a contract, right? So once you're outside the four corners of that contract, uh, good luck. Now you're in the hands of common law, doctrine of impossibility, doctrine of impracticability, doctrine of frustration. Not quite the same thing as force majeure. Very, very different legal concepts. So
Yeah, the
yeah.
force majeure issue obviously came up during the pandemic.
Oof, yeah.
And, I act as general counsel for a trade association and had to renegotiate the contracts with hotels for all of our conferences going out 2, 3, 4 years. And that force majeure clause became extremely important. And unlike with the civil code where it's fixed, the force majeure situations are already laid out. Each of these contracts had a different definition of what constituted force majeure. And as you rightly said, some of them required that performance be impossible.
Mm.
Others, a little more relaxed, would say that force majeure occurs when performance is commercially impractical.
Uh-oh.
Oh no, did Steve pause for you?
Yeah, he did for me as well. I'm
Oh no. Well, it's unfortunate because he's right in the middle of his thought. I'm sure he'll be right back. Uh,
Yeah. All right. Well, we'll kind of wait for him to come back, but just picking up from what Steve was saying. I mean, there was so many cases. Really, I mean, COVID really brought. There was just so many debates. There's so much litigation really on contractual suspension because of the pandemic, and you would get into these kind of debates about, all right, well, yeah, well, the pandemic itself was a unforeseen act of God, etc. But yeah, but the lockdown order wasn't, right. So the
Right,
lockdown order, which that's actually why we can't perform the contract. So wow, is that contemplated by the clause or not? I mean, you see what I mean? And so so there was a lot of fighting over issues like that, and it really just came down to how exactly were these clauses drafted. And so yeah, I don't know, Steve. I was just kind of like
Yeah,
talking
I
locally
don't
while
know
you
how
were offline.
much was lost when I was talking about impossibility versus
Mm,
commercial impracticability, and how, the latter phrase you could drive a bus through, basically. What's commercially impracticable,
right.
as opposed to impossible, that standard, you know, it's very hard to say it's impossible for us to perform our side of the contract. It's a much higher bar to reach.
Mm, yeah.
So that's when lawyers started focusing a lot more on those force majeure clauses, whereas the Europeans, as I understand it, it's more often fixed in the code, and it is what it is. But I think things are changing. Also, systems are merging, practices are becoming more similar. So I can't say nowadays how closely those force majeure clauses are negotiated in Spain, let's say. Um,
Well, I think it's probably fair to say that thanks to the pandemic, I think people are taking a lot more care these days in drafting them. I don't, let's face it, some people get lazy and oh, where's my force majeure clause? Let me just copy paste that in. And
yep.
I think people now are taking a little bit more care in how they draft their quote unquote boilerplate. But I hope, I'm sure of it. I mean, of course. So yeah, but yeah, I don't know, Steve. I mean, because you and I have spoken before about this idea of functional equivalence.
Yeah, well, it's that's what we try and find. We need to find functional equivalence, because those terms like force majeure or public policy, uh, they may be direct translations, and they may work as functional equivalents, but the lawyer has to understand that they may not really mean the same thing. The nuances may be different because the terms are so system bound and have all this history behind them. uh, you need to find those functional equivalents, because your translation from one language to another would otherwise be, multiply in terms of the pages required to reflect the source text.
Yeah,
But you have to realize that those terms of art are not necessarily going to mean the same thing. And I
yeah,
think that maybe that replies to, Latin expressions, for example.
yeah.
What do you think
Yeah.
of
I
those?
mean, yeah, I'd love to talk about that. But just another example that come to mind is estoppel. Very much a creature of equity. And and what
The
is
typical, you're stopped from making that argument,
well,
from
yeah,
making that
or
claim.
you're right, or we have equitable estoppel, we have promissory estoppel, and so and these are we've got 800 years of case law construing the extent of those doctrines and how they actually apply, and and so that the word estoppel carries with it a lot of meaning, and so just and it's a concept that just doesn't exist in the code. It's not in the civil code. So so they crack out the Justinian, and they crack out the doctrine of actus proprius, and rebus sixtanibus, and and so you try to fashion this idea, right? Like one cannot go against their own acts, actus proprius, and so yeah, it's a functional equivalent, but man, it's yeah, it is right, but not exactly, not exactly right. Like one thing, uh, just have different legal natures, right? And so it's what again, it's just something for I guess the work of the legal linguist. I don't I admire it. I don't know how exactly you guys tackle it. Um, um,
Well,
you know,
I think you need a legal background. These are
mm,
actually issues of comparative law, not just
yeah, yeah,
translation.
exactly, exactly. But you were asking, you mentioned about Latin, and I'm always kind of fascinated because again, like I kind of operate in this strange space, between American, Spain, and so it's funny. I'm always fascinated by the fact that common lawyers and civil law lawyers, we like Latin terms. We use Latin terms, but oftentimes we don't use the same Latin terms, right? So and there's nuance to that too. And sometimes we'll use the same Latin terms and we give them kind of different meanings, right? So but like that the Spanish. It's funny that the Spanish they call it Latin canino, dog Latin for some reason. I don't know why, but yeah, I mean, like in the States, we like terms like ipso facto, or we like ad seriatim. We like dicta, and they like obiter dicta. They don't like to say dicta. They like to say obiter dicta. We talk about the onus, but again, as a New York lawyer, I love res ipsa loquitur. The thing speaks for itself. No further questions, Your Honor. And you say that here, and somebody will look at you like something's wrong with your mouth. Like they don't really know what that is. But concept like caveat emptor, right? Which is, oh my God, it's so central, right, to contract law, right? It's very we again, Americans, we like list pendants, and I work by myself right now, and so I like per diem, right? That's how I
Yeah.
like to charge. Now
And the
I don't
Spanish
know.
equivalents aren't, it's interesting that often the European use of the Latinisms doesn't necessarily mean the same thing as the American use of those same Latin phrases. So we actually have I've got a dictionary here of el Latin juridico, and we're actually often need to refer to the definition of that term in Spanish and then go compare it to what Black's Law Dictionary may say
Right.
about that same phrase in Latin, and make sure that they line up before we simply either translate it or leave it in the original Latin in the documents that we're translating.
Yeah, it's so interesting. I mean, but yeah, it makes a certain sense, right? So when a common law lawyer talks about caveat emptor, um, you know, referring to, I don't know, let's say 800 years of case law, construing and considering the limits of that, right? And the limits of meaning there, like how far does that actually go, right? Um, Conversely, the civil law lawyer, yeah, understands that concept perfectly, and again, they got Justinian in their hands, so they know all about caveat emptor. But I'm not quite sure they actually have that 800 years of case law construing it, and so yeah, it's not surprising that you have instances where you're using the same term, but but each of the parties has maybe dramatic differences about what it actually means, and so it's or not so dramatic, maybe subtle differences, but subtle enough that it may lead to problems, right? So it's an interesting thing, right? Like how language conveys meaning, right? And that involves the speaker and the recipient, right? So we can speak and it's great, but the recipient is understanding something else. We're not really communicating, right?
So what would you say is the biggest challenge for Spanish lawyers in international dispute resolution? What are one of the biggest problems that you think might be out there?
Well, yeah, I mean. I'm sorry, I'm just shifting gears from Latin here. I'm just having such a
Yeah.
grand old time, talking about, fumus boni juris. And all these things. You can tell my Catholic school upbringing, I'm just missing all that Latin. No, but I mean, but jokes aside, I mean, I think it's just just to end that last point, I just would just stress that, and I'm so glad you showed that book before, because you know don't assume that because you're using the same term that you're actually conveying the same meaning, right? And I think that's great that you guys actually have, a book there to tell you what's the Spanish meaning of this before we start throwing terms around. I think that's spot on. I agree with that. But going to, when you ask me what's the greatest challenge for Spanish lawyers in international dispute resolution, again, once more, with my preface to my colleagues in this field. I mean, we're dealing with very sophisticated people, very prepared people. I'm sorry, I just got distracted because I saw a comment coming up from somebody. But anyway, going to the biggest challenge, right, and particularly for the younger folks or the newer folks coming in is, I think it has to do with a little bit with how their Spanish lawyers are taught to write and to plead. I think they tend to be very formulaic. If you were to read Spanish pleadings before the courts, you'll see that they follow a very careful format. It's very almost scientific. Designed to really set out like the entire legal hierarchy of the law, right? So from the Constitution all the way to the law or the regulation at issue, right? So before saying, instead of coming out and saying, hey, this is a wage and labor discrimination case under section da da da. No, they'll tell you, well, according to the Constitution, the government has a right to regulate in this area. And then there was an organic law that said that the government now has power to. And then there was another Real Decreto that elaborated on that law, which then brings us to today's law, right? So it'll be like 17 pages until you actually get to the law at issue of the case, right? And so. And then that's not an accident. I mean, there's reasons for that. It's basically because if you miss one of that thing, then the whole case, it's kind of like a house of cards. The whole thing falls apart. So, the thing is, though, and particularly I say this to, common law lawyers listening to this. I mean, it's difficult reading that. If you're not used to it, you really can get lost before they get to the main point. There are reasons for it. It's not just to be fancy or anything, right? But I think also Spanish lawyers, civil lawyers, they tend to use longer sentences. It's a sign of sophistication and intellect, right? Like that you can have this page-long sentence and the syntax is all perfect, and that's a sign that this is a learned and professional. Another thing too, like they're not quite as accustomed to when they're pleading, to discuss, the colorful facts of a case that they might be citing. Generally because, Spanish court decisions don't usually have extensive factual sections, like common law cases have, right? So, again, if you're reading, Spanish cases, and I wouldn't say case law, but I'm saying cases, you'll see that the case will usually have a very short cursory mention of the facts and then go straight to the legal the rule and how it's construed. So, common law lawyers, and you guys, I mean, correct me if I'm wrong. I think we're trained really from law school, really in advocacy. We're taught to, get to the point, skip to the main point quickly, tell a compelling story, make references to your evidence in the cases supporting you, whatever you're arguing. But man, make your case, and so we're, that's the thing. And I think, and we're always trying to, at least I've always tried in anything I've ever written is, I want to make it as easy as possible for the judge or the arbitrator or the panel to decide in my favor. As a human being who's reading my pleadings and I want him to decide in my favor. So really make it easy for the guy. I mean, really, let him go have dinner with his kids at some point. You know what I mean? So you really, do that. And so that, again, this is what I mean by the culture clash, right? So in other words, if you've been trained in this very formulaic way, now you're doing international dispute resolution. You really have to, as the Spanish say, cambiar el chip, like kind of put that aside and really, because again, not only is English the lingua franca of ADR, but also these kind of this advocacy style is really more of what's used in international dispute resolution. So I think that's a huge that's a big challenge for people coming in. Um,
It's,
you know,
I was thinking a little bit about this. Part of the problem, and I don't know what approach the arbitrators take, but the civil law system kind of uses a deductive approach. They're going from the general principles to the specific case.
yeah, I think that's
And
right.
that's why there's all this explanatory material in the pleadings, um, about the law. Whereas in the common law systems, it's more of an inductive approach, going from the case and then applying the law to the facts of the case. And I think that may account for some of the problems, um, in these different approaches, and why a Spanish lawyer may want to adjust their typical deductive approach to take into account this other way of approaching dispute resolution. I don't know
Yeah,
what you think about that, but that's
yeah.
kind
I
of
mean,
my
look,
thought.
I mean, I again, take my hat to Spanish practitioners. I mean, the real seasoned practitioners do this very well, and I meant people here that have been here doing this for 30 years, so they really know what they're doing. I'm just saying that they have to work very hard at it, because it's just not native to their culture, right? So, so if you spent 10 years litigating before Spanish courts, and now you're going to move into ADR, yeah, it's a challenge to
Yeah.
change the chip, right? As the Spanish say, right? But I don't know. Let me. I hate to turn this into like the Pete and Steve show, but I mean, my question to Steve is, so what do you think about translating things into plain English? Because I'm talking here about, yeah, you're an advocate, and it tends towards plain English. Make it simple, make it understandable. But I think it's a larger issue. This idea of translating into plain English.
Yeah, that's a good question. It'll take us to our next our section, both Ask Steve and Controversial Opinion section. So, Steve, what is your controversial opinion for this episode?
So, are you asking about where I stand on the plain English movement, or about translating a complicated document in one language into the plain language of the other language? So let's say it's a very complicated Spanish document. Should you be translating into plain English? Is that kind of the question?
Well, what's the most controversial? It's the controversial opinion section.
I think the controversial one is that you know translating a complicated high register document, into, let's say, a Spanish document into plain English is not appropriate. I've seen translators post a lot about needing to translate into plain English, and I would say that is completely inappropriate. It's not the translator's role to change the register of a document from a high register to a lower register that may be more comprehensible to the layman, especially when these are documents between lawyers. The lawyers should know how to deal with a sophisticated document with a high register that's using complicated language, because it's a technical language. That's what they're trained in. If it's a document designed for the public, that's one thing. But if it's documents lawyer to lawyer, there's absolutely no place for the translator to be, I hesitate to say it, but dumbing down the document. It's not the role of the translator. They could be misconstruing phrases and concepts. It's just not appropriate, and I can't stress this enough for any translators watching this. That is not your role. The role of a plain English or even plain Spanish is for the original drafter. They may want to use those principles to make their documents more easily comprehensible. Um, But that is not the role of the translator. The translator needs to reflect that document as it is. I don't know what you two think about that, but that's my very strong opinion. And it can be controversial in certain circles, but it is what it is.
I'm mystified. I completely agree. I don't. I think it's really seems like a matter of common sense. I mean, if you're uh, translating in a fashion where you're actually uh, adding your own interpretation to something, you may be affecting legal relationships. You may be exposing that client to significant risk. I mean, so it's a pretty kind of dangerous thing, and so I'm surprised that that would generate so much controversy. It's interesting.
Yeah, it's been controversial when I voice this opinion. You know, some people
Mm,
are shocked. Shocked, I say, I'm shocked. But I am a lawyer. I am more or less bilingual, and I would never take it upon myself unless the client instructed me to do so specifically. Obviously, they're the client, but otherwise, we would never do that. And it's it, it's okay to rearrange sentence structure in my opinion. Often the English and the Spanish are the reverse in terms of the subject and the object of the sentence. You do need to rearrange structure often for it to read well in the English, but you're not changing what we refer to as the register. You're not using simpler language. You're using the same functional equivalents. So,
yes.
it still needs to approximate the original structure. Um, but I think it's pretty clear where I stand on this controversial topic.
Great. I've actually been asked, where do you stand on plain and simple English? And usually, plain and simple English is what you want to use. I mean, sometimes, yes, there's contracts and there's formal environments, but often lawyers spend so much time in contracts and documents that they'll take that extremely formal, you know, way of communicating and then speak it to a client who's just mystified and needs a translation. And and then
Yeah.
often earlier, I've even seen a Canadian judge say, make your case to me, and make it simple
Yes.
and like argue it. And so that's kind of, when what I've seen in my career. But thank you,
And
Steve.
I was
Go
just
ahead.
going to say, if you've gone through the exercise of taking a complicated subject and presenting it on paper, it's much more difficult to be concise and short and to the point in a single page than it is to just throw everything on the wall in 5 or 10 pages and hoping something gets through. It takes a lot more work to cut that down to the essentials in a well written way to get your point
Mm,
across.
yeah.
Yeah. And if someone gets called verbose, then maybe they can look into it. But thank you, Steve. Peter, your turn. Do you have a controversial opinion for this episode?
I do, but something I was just reading the comments here, and and I wanted to flag it up because I thought it was great because she's explaining to me what Latin canino means, like dog Latin, and no, I really no, I think it's appropriate because what she's explaining is that it's referring to barking in Latin, right? And this idea that people will bark terms to give the impression that they really understand, and it's just it's bullshit, and so I really like that, and so I really appreciate that comment, and thank you for teaching me what Latin canino refers to. So, but I really like that, and it's appropriate, right? To I guess to mine idea about how language can really be a minefield. My controversial opinion, right, is that legal English can be a minefield, and it's dangerous to use without full knowledge. Monkey with a handgun, right? I mean, it's words in English come with I don't know, right? Somebody correct me here, but I'm going to say 800 years of case law construing their meaning. Great minds have been, many great minds have put those great minds to exactly that task. Lord Denning, Justice Marshall, and Justice, Benjamin Cardozo. Defining fiduciary. A punctilio of an honor most sensitive. I mean, my God, it's like poetry, right? But like people, it's like a myth I've seen with some Spanish lawyers, not everybody, but they think that, the reason in America you always form Delaware corporations must be a tax haven, must be some sort of fiscal tax paradise type thing. And it's like, no, it's because there's 200 years of chancery division case law, like construing the meaning of every single term in corporate law. Picking Delaware laws is not for tax reasons. It's because you want, if in the event of any kind of a dispute, there probably has come up over the last 200 years, and some pretty smart judges have dealt with it, So, in that sense, like guys jump in and cut me off here, but in a sense, like the English language is kind of like blockchain that way. If you think about it, like no other language carries that kind of accessory of meaning with it. It's probably the language's best unique selling proposition. If you think about it, I mean, other languages can be just as, if not as precise as English. I mean, just like English, in my opinion, I mean, Spanish it's a strong language. It can be strong. It can be supple. It has, God, it can have the sharpness and accuracy of steel. But it can also be gentle and pliant. It can be courtly but without the sentimentality. It can be intellectual, but without being as cold as French. And it doesn't have these overflowing melodies of Italian in it. So Spanish is a language. It's never weak. It's not sloppy. I think Carlos Quinto, arguably greatest king of Spain, Holy Roman Emperor. He said, I talk to my generals in German, I talk to my diplomats in French, and I speak to God in Spanish, right? So he wants to make sure, whatever he's saying, when he's confessing for killing all those Protestants, he's making sure it's he's super clear, right? But, if I had him in front of me, I'd be like, yeah, but, if you wanted to write a contract or an international sale of goods, I'd highly recommend you do that in English, as long as English law was applying, or common law was applying. Because, I think if what you're looking for is greater certainty when it comes to meaning, right?
Well, I don't know. I mean, that may be a bit of an American-centric viewpoint, I think. I think there is an argument to be made that, having to think about these hundreds of years of court precedent behind the language of all these terms and concepts, it's a lot of work, and it's a lot to think about, as opposed to just relying on the code and saying the code says this and that's what we're going to refer to, and it's simple, it's plain, it's done. And I think there's an argument to be made for that as well. Which is better? I don't know. I think the main thing to keep in mind is that terms are system bound, that legal terminology in each language is going to be connected to that system and its history and the precedent and what the courts have said, and what the legislator has said about those terms. And so that is really what you need to keep in mind. Which is better to draft in? I think we all have our own biases, but that's just my opinion.
No, I can't agree more. And something you just said there, terms are system bound. I mean, that is, as they say in Spanish, una verdad como una casa. I mean, that is absolutely, oh my, amen, brother. I mean, yes. I mean, for so much of what you do, I mean, you really, writing a contract in Spain, I mean, you really need to have the legislation open in front of you. you were writing a commercial lease, for example. I mean, there just under Spanish, landlord tenant law, or whatever. Like there's provisions that are going to be in your contract. You put them or not, like they're automatically there. There's provisions that you can't derogate from. So no matter what the hell you put in a contract, it's like as though it's not there. Um, and so yeah, you've got to, as you're drafting, you've got to make damn sure that you're being creative only in those areas where the legislation actually allows you to be. I mean, so God, it's so true. It reminds me of an anecdote about a commercial lease in English. The client wanted to negotiate a commercial lease in Madrid, but insisted it be done in English. Even though the contract would be governed by Spanish law or submitted to Spanish courts in case of dispute.
That's interesting.
Yeah.
I've heard of this also and come across it, and I can see some problems with that. Is it a trust issue? Is there a fear that something would get lost in translation, or that one side's going to try and slip in some hidden advantage in the contract? What would be the reason for negotiating and signing a contract in English for a purely domestic Spanish transaction?
Well, as I just said, the important thing with that deal is, okay, being that it is being under Spanish law, make sure that in whatever language you're using, you've got the legislation in front of you. But which just kind of takes me like to this idea, how important it is to watch out when you're trying to force a square peg into a round hole. So you show up in Spain with your American contract, and you want to try to adapt it to Spanish legislation, or vice versa. I mean, or anyone. And I imagine this drives you crazy, both of you crazy. Is just when people download contract template from the internet and they try to wing it themselves and to save a few bucks. I mean, it's frightening.
We work mostly with large law firms and corporate entities, so that doesn't come up too much for us. But there is this issue of using American or British form documents in civil law jurisdictions. I chaired the Inter-American Affairs Committee of the New York City Bar Association for a few years. And at one point, we had some Chilean lawyers come up, and they were talking about the legal system there and financing, and humbly suggested that maybe the New York form, loan agreement template that was used by the firm for one of the big banks, maybe you want to think about adjusting it a bit for use in a civil law system. If there's litigation, judges won't necessarily know or be experienced with this form of contract. And the lawyer from one of the big firms banged the table and says, if you think we're going to slow down our deal flow for your little, and I won't use the expletive the person used, your little X jurisdiction, you've got something else coming to you. And I had to say, settle down, everyone. But it was this, there is this bit of, Anglo imperiousness about how their system is better, and everybody has to kowtow to it. And I think in some instances that could be shooting themselves in the foot if there is litigation and disputes over the meaning of these contracts. Again, just my opinion.
Amen. Amen. Yeah.
I have a quick story about that. It reminds me, I was helping someone, and there was a dispute about contracts, and then someone took the position of, we're the stronger side of this negotiation. You will put this clause in, and so I was helping write these emails of, oh no, we won't, because that would make it illegal in our jurisdiction. And
Yeah.
finally, and they kept fighting because they were like, well, we're right. You don't mess with our deal flow. We're the prestigious side here. And then finally, my client, head of legal, she got a call from another head of legal, and it was just a huge apology. We're so sorry. We didn't know it was illegal in your jurisdiction. And that just made
Despite Charlie's 30 emails telling them so, but whatever.
that was the highlight of my legal English coaching, was just responding to all of that with the law saying this will not be accepted. This is
Excellent.
criminal.
Well, so Charlie, what is your controversial opinion for today?
Great. So I do have one. I didn't have one, a couple of days ago, but my controversial opinion for today is that you can be a great lawyer even if you have a strong foreign accent, with the exception that a funny sounding foreign accent can hurt your reputation. But most advanced or ambitious learners don't have funny accents. I mean, I've coached European lawyers for almost 4 years. None of my students have had funny accents. They've had obviously foreign accents. Some of them have had strong foreign accents, a lot of them from Spain. But they're still easily able to, after working on this, able to command respect. Some were, leading teams of foreign lawyers, and so that's my, in a way, as a language teacher, it doesn't seem that controversial. But because every accent is so personal, and then it connects so closely to shame, that it's controversial in a way. Most people think, oh, I'm less than, because people will know immediately that, I'm Spanish or I'm French or I'm German. But I'd even say being ashamed of your accent, it's like a common problem that I have to deal with as a coach. And it's linked to being ashamed of who you are, because it just tells people where you're from.
I
It's go ahead.
Well, I think in Spain, partially, they have the problem of el sentido de ridículo, and it's a cultural thing. But apart from that, I think it's important the level of which the accent affects the speech. So if you're talking, you need to have a certain level at which your accent doesn't affect comprehension. I got off the phone, or I was on a Zoom call, and there was a person speaking. Their accent was so strong, I had to keep stopping and saying, What? Like, I did not understand them. And I know the Spanish accent very well. They were speaking in English, and I just couldn't understand about 50% of what they were saying. And that is where, I think a coach really comes in to help somebody with that level of difficulty. I don't know what you think, but
It reminds me, actually, I was with someone from France, and we were listening to the same Spanish speaker, and I understood everything. And the French person turned to me after and said, I didn't understand a word he said. Now, that's very important, because most people, I mean, we're three exceptions. We understand the Spanish accent really well. But if you're doing international practice with someone who, let's say it's a German international lawyer, just a random American, Brit, they're not going to know the Spanish accent as well as us. But really, that person was not fluent, and nobody can fake fluency for long. I've heard of lawyers that stop answering the phone, or they stop speaking in meetings. And that's really, you're leaving a lot of money on the table when it comes to career development. But at least, so that's I totally agree. Your level has to be high enough. But when it comes to accent, let's say you were understood. When so everyone's understood. Now we're just talking about accent. Well, who sounds more masculine, stronger, more decisive than Arnold Schwarzenegger? I mean,
in
his
English, yeah.
yeah, in English. I mean, I don't speak German well enough to listen to him in German, and apparently his German accent is actually quite rural. But
But it's Austrian, you know.
yeah,
It's
and
Austrian.
apparently
Yes.
rural Austria. But his accents, they announced where he was from, and they made him stand out in a good way. I mean, at first he was told, it's not going to work out for you with his accent. Maybe with the muscles, but not with the accent. And he once said that he had an accent coach and that he should ask for a refund. And maybe he should. But I'd also mentioned that, we've got a lot of Spanish lawyers listening. I wouldn't turn off a Julio Iglesias song, an Enrique Iglesias song, because they said an English word in a different way. I mean, they have such incredible music and voices that it's, in a way, it's exotic. And so exotic is when it's good, when it's not understood, when it's bad. And I'd also say, just for speaking, because we're not singers. If we are singers, it's not for our work. But Antonio Banderas' career proves that your accent can make you more remarkable, memorable, and unique.
I agree. I don't think anybody should care if you have an accent. The question is only if that accent is so strong that it interferes with your ability to be understood. And so you want your level of English to be good enough to be understood well, um, and don't give two thoughts to having some kind of accent. It's not a negative, and it can actually be a plus. So the danger zone is, not practicing and getting worse or plateauing. Peter and I have a common friend, who's Spanish after living in Spain for decades was just horrific. And obviously, I won't mention names, but it's amazing. You say, how can your Spanish be that bad? Have such a strong accent after so many years of living and working in Spain. And I don't know, maybe some people just have a block, and other people just don't care or don't want to practice enough to
Well, I
get
mean,
that
I think
better.
it's also too. I mean, it's also your ear. Some people have a better ear for language than others.
Interesting. Yeah.
It's like some people have a better ear for music. I mean, so that's just genetics, I guess, in some cases. So my father, who was from Madrid, and my father was a psychiatrist, and so he studied medicine here in Spain, and as a young man went to as a young doctor moved to the United States, where he made my saintly mother fall in love with him. So but imagine. I mean, so my father. As a psychiatrist, he spent his 50 years talking to people, and he never lost his Madrid accent. And I think actually he exploited it. I think, wow, who wants a psychiatrist without a really cool accent, right? Like Freud or something, right? So I think he was a brilliant psychiatrist. I mean, and so yeah, I think his accent actually really helped, with that, but it's interesting. It's like, as I just say, I mean, I have a really dear friend here in Madrid who is a very intellectual, like one of these very well read, very sophisticated, very scientific thinker, reads, Hayek, like reads Nobel Prize, like a really, a very sophisticated guy. And it's a shame because he both writes and speaks, and really tries to, translate his Spanish into English, and sometimes to disastrous effect. I mean, because it kind of mines his credibility a little bit, and it's kind of a shame, because and it's so funny. It's probably for another show, but it's so weird, like how some people have like a different personality in Spanish than they have in English. I don't know why that is.
Absolutely, absolutely.
I
In
find
fact,
that
for every
bizarre.
language you speak, I think it's said that you have a
I'm pretty
different
much the
personality.
same. I'm pretty much the same in
Oh,
either.
really?
But yeah,
Oh,
yeah,
I'm
like
much more
this.
personable in Spanish. There's no doubt about it.
So
None.
yeah. Anyway, you know. Anyway, yeah. So that was. I mean, so just going to your point earlier, like, so yeah, the really sexy, exotic Spanish accent can be really effective. Um, but really, as I think Steve was saying, you really do have to bring up the level, because it can, it can kind of hurt the reputation a little bit, the credibility. Um, I mean, it's kind of the My Fair Lady syndrome, right? Like, like the farther away from London you live or you speak, right? It's that Cockney, automatically people assume you're 40 IQ points lower, right? So it's just biases that people have. So,
I'll actually
Well,
add to that in a way because in English this is how I sound, and then in French and in Spanish I'm very different, and then I'm getting to the level in German where I'm starting to get this German personality. And I got really excited about it. I find language learning really meaningful. Everyone, if you're working on this foreign language, even if it's towards the end of the journey, like everyone here is advanced, but still, this is this is your lawyer's voice. This is
mm,
one of your most important voices that you'll develop, and it really can change your life. And this is the personality. Like your personality as a lawyer in English is going to be defined. And in fact, the better practice and better defined, the better. And what's really meaningful, I mean, I got that a few days ago with German, where I realized, like, not only do I understand something I didn't before, but the way I would speak would be like totally different. And I've never met that guy before.
Right.
I'm not good enough to speak German now, but it happens. And you're sorry, I cut you off, Steve.
No, no, I think you're absolutely right. I think for the Spanish speakers in the audience, the only thing I would say is that the Spaniards admire what we would consider or tend to admire, these long-winded texts, flowery language, this idea of eloquent variation, where the lawyers drafting a document don't want to use the same term more than once in a paragraph. And that, for example, drives an American lawyer insane, literally insane, because we are taught you use one term, that is the term you use, and you do not vary that term because you will create ambiguity in the document. And so this aspect of drafting using different terms for the same concept, if you've got an American, probably a Brit, but definitely an American on the other side, just realize you will drive them nuts. And we have to deal with this, and we have to make decisions. Are they really intending to use a different term and different concept, or are they really intending to say the same thing just with a varied term? And that's the kind of work that we have to do in making sure we get the translations right.
Mm.
Okay. Well, thank you very much. That's going to end our live stream for today. But before we finish, we'd like to thank our very generous sponsors. Today, we're sponsored by Charlie Shan Coaching. So that's me. I coach lawyers to sound powerful and effective in English. And I actually have room for 3 new students for the final leg of 2024. So if you're interested in hearing what it would sound like to enter the year of 2025 with confident and professional English, feel free to send me a direct message on LinkedIn, because we're only 2 months away from 2025 and time is running out if you want to get this handled before the new year. Steve?
Excellent. Well, at Juriscribe, we provide timely, accurate legal translations for our clients' most important corporate and legal documentation. Our translations are provided by lawyers for lawyers. And if you're interested, please contact me through LinkedIn or elsewhere and find out more.
Uh,
Peter.
yes, and at Nemea's Dispute Resolution, I provide international commercial dispute resolution services, acting as a mediator or arbitrator in either Spanish or English, online in some cases, or in person right here in sunny Madrid.
Wonderful. Well, thank you very much for watching. Thank you both for being here with me. And we'll see you next time.